Hi everyone, this is Sean Hayes with Hayes Attorney PLLC. In this video, what we're going to try to do is go through the three main types of estate administrations in North Carolina. At Hayes Attorney PLLC, we concentrate in the practice areas of family law, estate planning, estate administration, wills and estates, and as well as business law. We've represented thousands of clients across all spectrums of those practices of law. So getting into this, just a few caveats. This is for general information purposes only. It is not a very deep dive, but more of a mid-level dive into the types of estate administrations in North Carolina. So as you can see in the presentation, there are three different types of estate administrations in North Carolina. You have your formal administration, which is your typical administration. We'll get back into that in a few minutes. And then you also have a small estate administration if it qualifies as a small estate, and you also have a third type, which is called a summary administration. And they are all three different, and they all require their own rules, their own set of procedures that one must go through in order to complete each type of administration. So in a formal estate administration, this is the first type and the most common type of estate administration that is conducted in North Carolina. As I'd indicated earlier, it is your standard or typical type of administration, and it is a full administration of an estate where basically all required steps and procedures are required to be followed in order to complete a formal or full estate administration. And I've listed some of the phases here that one would go through. You're going to go through the application phase, and we have another video for qualifications that covers the two general types of qualifications on how one could qualify to administer a formal or regular estate in North Carolina. If you would like, you can check out that video on YouTube. But you'll start with the application phase or the qualification phase, where someone would qualify to become either administrator or executor, executrix over an estate through submitting those formal documents and being approved by the clerk of court for either your letters of administration or letters of executor, which would give you the power to serve. The second general phase would cover with respect to creditors, doing your creditors notice, your publication notice, and then properly handling any and all debts of the estate, making sure that you have went through that procedure and process properly and formally so that debts can be barred at some point in time, so that someone can't come back later on after the estate is closed or later on in the estate process and say, hey, I'd like to file a claim of lien, or I have a debt against the estate, when you have already distributed out property or assets of the estate to heirs. Then the next phase is your 90-day inventory phase, which is more of a comprehensive list of all the assets of the estate to give everyone a very good idea of where the estate sits as it relates to its assets. And then the final phase would be the final accountings, which sometimes can run into annual accountings before final accountings are filed, in order to distribute out the assets of the estate properly according to law, and then properly closing out the estate in North Carolina. So that in general would cover your first formal or general type of estate administration in North Carolina, the formal estate administration. This next type of estate administration is what's called a small estate administration. So it is not as formal, it is not as thorough as a formal or full-on, typical estate administration that is conducted in North Carolina. But in order to qualify, in order to administer an estate according to these procedures, the estate itself must qualify as a small estate in North Carolina. So in order to do that, generally speaking, the assets of the estate must be less than $20,000 in total. Or if the surviving spouse is the only heir of the estate, the total assets can be less than $30,000, including after a spousal allowance is distributed to the spouse, the surviving spouse. Now, what we mean by spousal allowance, just quickly, would be, the statute in North Carolina allows for, whether there's a will or whether there's not a will, you can qualify for a small estate, but whether there's a will, whether the spouse has left anything in the will or not, they can apply as long as they meet certain qualifications and up to the certain time period. A surviving spouse, whether they're left anything or not, can file and apply for a spousal allowance. Now, as of the making of this video in North Carolina in 2024, that amount is the first $60,000 of those, generally speaking, estate assets. And so, let's say that the estate assets of an estate were $80,000, and a spousal allowance would allow for $60,000, and then so after that, the remaining assets would be $20,000 of the estate. Theoretically, that estate could qualify to be administered as a small estate. Now, there are caveats with respect to this that you would want to get into and speak to an attorney about if there is real estate involved, because in the event that you would want to transfer that real estate in the future, that is something that you would want to address before deciding whether or not to proceed with a small estate administration in that situation. Now, the last general type of estate administration that can be conducted in North Carolina is called a summary administration. And just like a small estate administration, it is not as formal or as full of a process and procedure as the full estate administration that I covered earlier in this video. But again, in order to conduct a summary administration, you've got to meet certain criteria in order to qualify in order to conduct a summary administration. So you either have to be the sole heir, or be left everything in a will as the surviving spouse. So if you were the sole heir, without a will, you're the sole heir, or there is a will and the surviving spouse has left all of the assets of the estate, then that particular estate could theoretically qualify as to be conducted as a summary administration. The unique thing about this, distinct from a small administration, is that there is no asset limit. So like the small administration, where it had to be under 30 or under 20 generally, or under 30 for a surviving spouse, even after the spousal allowance. In a summary administration, there is no asset limit. It could be $2 million, if you wanted it to be. The other distinct characteristic about a summary administration is, whereas other types of estate administrations, the estate is responsible for the debts, in a summary administration, the caveat is the surviving spouse would inherit the debts in this situation. So to conclude and summarize, there are 3 types of estate administrations generally in North Carolina, that being the full own estate administration, small estate administration, and the summary administration. As described in this video, there are distinct requirements for each. If you have questions about estate administration, the process, or which ones you could potentially qualify in order to have administered, please feel free to reach out to us. Our email is on the page here, office@haysattorneync.com, or our phone is 336-633-4529. You could also obtain additional information at our website, and that's www.haysattorneync.com.